Welcome everyone. Welcome to the Business Law 210s. Our subject today is about discharge of contract. What does it mean? A discharge of contract ends the legal relationships of the parties. It terminates the vinculum juris or legal tie between the parties. Termination of a contract. All contract must eventually come to an end. In a legal sense, the party must be discharged, free, released from the obligation which they undertook under the contract. A contract might be said to be discharged when it is terminated so that the parties are no longer under a duty to perform the contract. Termination of contract. There are various reasons for a contract to be terminated by either party. These reasons to discharge a contract include performance, agreement, frustration, and breach. By performance or tenders, there are two things: the actual performance and the attempted performance or tenders. The actual performance is when both the parties perform their promises. The attempted performance or tenders only can offer to perform the obligation under the contract. Next one, we are discuss deeper on discharge of the contract by agreement. By agreement or by consents, there's two important things, which is by implied consents, where mutual consent included novation, rescission, alteration, remission, waiver, and mergers. The second thing is by express consent. Discharge a contract can be discharged in the following ways. Yes, novation, alteration, rescission, remission, and waiver. And by novation means that replacement of existing contract by new one. By a new ones might be between same or new parties. While the alteration when one or more terms of the contract are changed. The third thing is about rescission. This is when the situation happens if the party cancellation of contract with mutual consent. Next one is novation. There's two types. Change in party. You can also do without change in party. This is happen when there's a substitution of new contract for existing one, maybe between same or new parties. And next one is the alteration. The alteration happens when one or more terms of the contract are changed, means so change in one or more of the material terms of the contract. The two types of the change, material alteration is one which alters the legal effects of the contract. For example, change in the amount of money to be paid, rate of interest, or the name of the parties. The second one, immaterial alteration. It is correcting a clerical errors in figures or the spelling of the name. Novation means that you can change the parties. Old contract is dissolved by a new contract, and there are two types of contract. While in the alteration, as mentioned on page 12, their parties remain the same, no dissolution, and there's a one contract. What about remission? Remission is acceptance of lesser fulfillment of a promise that was made. Waiver, in the other hand, intentional abandonment of a right which person is entailed to under a contract. Okay, now we move into the next subject, which is waiver. Waiver means the abandonment of a right which a person is entitled to, means abandoning the right. When a party